My name is Patrick Tott. I'm the Chief District Court Judge for the 3rd Judicial District in Iowa.
Right. And tell me, how does the shortage of contract court-appointed attorneys affect the Iowa judicial system?
Well, in Iowa, persons are entitled under the Constitution to representation by an attorney anytime their liberty interests are at stake. And in most common situations, that's a criminal context where there are criminal defendants involved who could go to jail or prison. But there are also a lot of other areas where that can come into play as well. For example, in civil court, if a court order is violated by a person, they can be subject to contempt sanctions. And with the contempt sanction comes along with it the possibility of jail or time if they are found to be in violation of a court order. Then there is also many times, and almost every time, in juvenile court where parents and children are entitled to court-appointed counsel as well if they financially qualify, which is nearly in every case in juvenile court. So there's a wide range of need for attorneys in order for the court system to be able to function in each of these particular areas. And in addition, there's also the mental health and substance abuse committal processes. Those individuals are entitled to representation by counsel as well at state's expense. So when there's not enough contract attorneys or not enough court-appointed attorneys available, it becomes very difficult for the court to be able to appoint attorneys in all these various types of cases. In Iowa, the court-appointed system has been through the State Public Defender's Office since 1989. The State Public Defender currently has about 170 attorneys in their office that work out of 18 local offices spread out throughout the state. Those attorneys by themselves are woefully inadequate to meet the need for indigent defense. And as a result, the State Public Defender contracts with private attorneys who are not employed by the State Public Defender to provide those types of services to the public. And as of today, there are approximately 590 private attorneys who accept contracts through the State Public Defender for this purpose throughout the state. Now, compared to 20 years ago, 590 might sound like a large number, but compared to 20 years ago or so, it's a woefully small number, and it's a woefully inadequate number to meet the need for contract attorneys across the state. And this obviously impacts the judicial system in a lot of different ways. First of all, with there being an inadequate number of attorneys available, it oftentimes becomes very difficult for the court to find an attorney available to appoint in any given case. This includes criminal cases as well as the other ones that I described a few moments ago. The State Public Defender provides us with the list of who the contract attorneys are for each individual county, but oftentimes there are either no attorneys for certain types of cases on that list, or the attorneys that are on the list have conflicts, or for some other reason can't accept an appointment in an individual case. That then causes the court to have to search out for other attorneys to take those cases. And normally that means going outside of the county, sometimes even several counties away, to find someone to take an individual case. Now, when a judge has to do that, that takes away from their other duties and their other responsibilities that they otherwise could be working on, which causes delays in having hearings being conducted, causes delays in the courts being able to issue their rulings on hearings they've already conducted, and basically just slows the entire process down. For example, even this week, I have a Class B felony in Woodbury County that I've spent a significant amount of time looking for a contract attorney to appoint, because number one, there's a conflict for the Public Defender's Office, so they can't take it, their attorneys can't take it. The contract attorneys in Woodbury County have conflicts as well because there's multiple defendants involved, and other attorneys' caseload is not permitting them to take on a case of that magnitude at the current time. So I'm spending time going through the list of possible attorneys, calling them, seeing if they're available, until I'll ultimately be able to find someone. But again, that all takes away from time. I could be conducting a hearing for another case, could be working on a ruling to submit on a custody decree or divorce decree or some other ruling I have under submission, all of which slows down the process for everyone. In addition, for those attorneys that are taking cases, they commonly take cases or take appointments in multiple counties. This will lead for an individual contract attorney to perhaps have to be in a hearing in 2 different places, which oftentimes 2 different counties at the very same time. Obviously, that's impossible for them to do. which leads to at least one of those two cases having to be continued because there's no way for that attorney to do two hearings at the same time. Now you might say, well, why not have two different attorneys in two different cases? Well, that's the root of the problem. There aren't two different attorneys to appoint in the two different cases in the two different counties. And if we're tough on these attorneys and say, well, no, you've got to be here for your hearing, they're just going to say the heck with it and walk away and not take cases at all, further exacerbating the problem. So we're really left in, as part of the court system, with no alternative but to grant continuances in one of the two cases, which again clogs up the schedule, puts out hearings further, delays my ability to schedule a divorce trial or a custody trial or a civil dispute trial because I'm having to use more time to cover the other hearing that should have happened on the day of the other hearing as well. This slows down the progression of all cases, criminal cases and civil cases, and just because of the limited amount of time and space that's available on the court calendar. And this creates a huge burden on the judicial system because we're required to operate within the constitutional requirements for defendants in criminal cases, most notably their rights to a speedy trial, as well as the court's own goals of trying to process civil cases in a timely and prompt manner, which again becomes very difficult if our schedules are all jammed up.